Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Is everyone there? Good morning. I welcome you, Mr. Sutter, and I welcome you, Mr. Sales, to our Zoom court. I am Justice Patricia Alvarez. With me is Justice Luz Helena Chapa and also Justice Lori Valenzuela. Today, we will hear your arguments in this case. Let me get this. Okay. Give me a chance that I'm looking for. There we go. It's the appeal of 04-2455 CB Williams et al. Versus Guadalupe-Blanco River Authority et al. The appellant has 20 minutes to argue. The appellee has 20 minutes to respond, and then the appellant has 10 minutes to reply. As Mr. Cruz told you, we will take a 5-minute break, and then the cross-appellant will have 20 minutes to argue. The cross-appellee will have 20 minutes to respond, and the cross-appellant will have 10 minutes to rebut. The timer is showing in the Zoom window. You can all see it, I'm assuming. Correct? Okay. Please stay within your allotted time. When the light turns red, your time has expired. We will probably not grant additional time, but we will entertain any motion for additional time. If we give a party additional time, we'll give the other party equal time. Right now at this time, I know that Mr. Sutter and Mr. Sales will be presenting the first part of the argument. You won't split your time on that first part, correct?
Correct.
Correct.
Okay. Let's see, if you need any water, please feel free to drink water. We're going to be here for a while. And that's about it. Can you please make announcements?
Yes, Doug Sutter for the appellants, Williams et al., homeowners.
Travis Sales and my colleague Macy Reesner-Stokes on behalf of the Guadalupe-Blanco River Authority and its officers and directors.
Mr. Sutters, would you like to start the argument?
Yes, may it please the court and counsel. As the district judge agreed with us, Justice, that this is a case of first impression by the property owners along the Guadalupe River in the Guadalupe Valley. And they are also called by GBRA as stakeholders. And that is for a purpose, and I'll discuss in just a moment that. But the reason this is a case of first impression, this is the first time that a river authority has not followed the Texas Administrative Code to repair, replace, and maintain its dams. The record shows that all of the other river authorities, Lower Colorado River Authority, the Brazos, the San Jacinto, and all the others in the state of Texas have done so. So there has never been a need for the adjacent property owners to bring claims for loss of use and enjoyment for the historical purposes of their property, or to bring a subchapter B Declaration Act under Section 2007 of the Texas Government Code. Just recently, the Supreme Court has gone over 2007, the Government Code, which I'm going to speak to in just a few moments. But suffice it to say that GBRA owns 6 high-hazard dams on the Guadalupe River. And 2 of those dams in the past 4 years have failed. During the past 2 years, the Guadalupe River, or the GBRA, has ceased all maintenance whatsoever by their own admission on these dams. And as I said before, this is a case not by taxpayers, not by citizens in those capacities, but by property owners. We are appealing that portion of the district court's ruling on the plea to jurisdiction. 2 things were filed by GBRA, a plea to jurisdiction and no evidence motion. Only the plea to jurisdiction was ruled upon by the district court. The district court, as you know, did not grant the motion with regard to jurisdiction, but did grant the motion with regard to our declaratory judgment acts, our estoppel acts, and our ultra-virus acts. The standard of review today for this court is a de novo one, with regard to the plea to jurisdiction that was filed. The court determines on a plea to jurisdiction only the pleadings of the property owners. GBRA has made an argument that the Shady Shores case applies and that we are required to put on evidence. That case applies only if there is a no evidence motion for summary judgment that was ruled upon. No evidence motion for summary judgment was ruled upon, and none of the parties have appealed from that, and GBRA did not press the trial court to rule on their no motion. So the burden today is on us, but at the same time, it is based solely upon our pleadings. Now, this case is somewhat unique because we did have a year of discovery in it. Normally, the first thing that happens in the case is that you have the plea to jurisdiction, a ruling on the jurisdictional issues, but under the temporary injunction order, the court ordered and the parties agreed that the plea would not be argued until after 98% of the discovery was finished a year later. So it's unique in that way. And the reason you see that we have 5 amended petitions in this case is as we learn facts, we amended our petition knowing that we would have to have those facts clearly pled with regard to the takings cases or the taking claims that we have. And what's also important is that at no time did GBRA ever specially accept to any of our pleadings. So they were clear and on to them and had no problems with understanding them. So the court here has deliberately construed our pleadings, has to take the facts asserted as true and to look at the pleader's intent, which we believe that we have in our 5th amended petition sufficient for the declaratory judgment, estoppel, and ultra vires. Now, the first issue, justices, in this matter is standing. And we believe that GBRA has always had a fundamental misunderstanding of our standing. Their position is that we are just adjacent property owners like the San Antonio conservation case, a nuisance case, where they were claiming that lights from a bridge cause a nuisance and a diminution in value of the property. That is not the case.
May I interrupt you, Mr. Sutter?
Sure.
And by the way, I forgot to tell the attorneys that whenever we have a question, we'll raise our hand, and if you could stop, please. Assume with us that you are correct in the standing issue. Go to the next issue, please.
Okay. The next issue is whether or not we have a cause of action for a declaratory judgment. I think traditionally judges look and say, you can't bring that type of cause of action against a governmental entity. But what the trial court did not focus on, and I don't think that GBRA did at all in the briefs we did, is the section 2007 of the government code, which permits us to seek a declaration with regard to the resolution of GBRA with regard to their dewatering of the lakes. And I will quote today from the San Jacinto River Authority that came out in April from the Supreme Court. And this is exactly the cause of action that we brought, section 2007-042. And that is where we can move to rescind a decision of the GBRA if a takings impact study has not occurred. And in this case, it is without any doubt, and there is no issue that no takings impact study was ever undertaken with regard to the GBRA. And under the statute, we are entitled then to move to rescind that decision. And
yes, sir, but let me interrupt you. I think you really skipped a step that we're really interested in, and that's immunity.
Okay. With regard to the governmental immunity under Chapter 2007, the immunity is waived. And again, the San Jacinto River Authority, the court talks about that issue. Under 2007, it states as follows: the state has waived its immunity from suit and liability to the extent of liability created under Chapter 2007 and has authorized suits against political subdivisions to determine whether the governmental action or political subdivision is a taking. And that waives, as a matter of fact, the immunity is waived thereby at that point because there was a taking that was with regard to the property interests of the stakeholders and the property owners under this case. And as the
But let me interrupt you, Mr. Sutter. The taking, and that's where I'm having problems with the taking. There is how can the authority take anything from your property if it's only its operations are only, or it's a project that's only constrained to the water that's in the lakes, that has nothing to do with your property owners?
Okay, well, it does, Judge, because of this reason. Since 1933, the GBRA has issued permits to the adjacent property owners of the lake to make improvements. And under those permits, and we have a bench book that we submitted to it, the Guadalupe River Authority has an application for a modification of its own properties. And what it has done is
and excuse me again, and that's where I'm having problems, and that's why I'm asking questions. And I apologize for interrupting you, Mr. Sutter. But that only pertains to the dock. It doesn't pertain to their homes.
No, Judge, it pertains to retaining wall, piers, boat slips, boathouses, which are built on the river bottom and attached to the real estate. And the pleadings that we have and the evidence that we have submitted shows that the valuation and appraisals of those properties include those improvements that are attached to the real estate. They are part and parcel of the real estate. And therefore, that's where we have not only the standing, but also the fact that that property, that is the taking. Because when we go in pursuant to these permits and in reliance and following all of the instructions to make these constructions and improvements that they say themselves on the permits, we own those. The property owners own that. They are attached to the property and make up the valuation of those properties. And the takings is when they take the water, because under the permit, the only two ways that they can do anything is, one, if they determine that those improvements that are attached to the properties are unsafe, they can require us or the property owners to take them down or to replace them. Or if they decommission the dams under the Texas Administrative Code. That's the only two ways that they can revoke those permits. And that is where we have the standing and the property right. Because if you go back in the pleadings, as well as in the documents that we have submitted, the Guadalupe Appraisal District and the appraisers for the Guadalupe Appraisal Districts appraised the properties, not only based upon the improvements on the land itself, but attached to it. Because if you don't have those improvements on those properties, the valuation is substantially lower. And that gives us, that is why GBRA has always fundamentally misunderstood the property taking. This is not like we're just sitting on the side and we have a problem with what they're doing and we think it's going to affect our property values. Courts have said, you don't get that. You have to have an actual property. And we do. There is no issue in this case that those improvements are owned by the plaintiffs. And that is why GBRA calls the plaintiffs stakeholders, because they have a stakehold in that lake. And that is a piece of property that has been taken. And getting back to the declaratory judgment issue, is the district court said we don't have a right to a declaratory judgment, but under section 2007, we have an absolute right that the Supreme Court has just mentioned to a declaration from the district court that the government's actions should be rescinded. And in this particular case, GBRA had 14 months to comply with that provision. They did not comply with that provision. They did not do a takings impact study. And the reason I say they had 14 months is we sent a demand letter in June of 2019.
Mr. Sutter, if I might interrupt you, please. Excuse me. Let's assume that we agree with you on your standing issue. You just spoke to government actions. Can you specifically can you with specificity state what regulatory actions you're talking about?
Yes, the board of GBRA resolved to dewater the lakes in 2019. That is what started this entire lawsuit and the temporary injunction. And when they resolved to dewater the lakes and to leave the dams alone and not to repair them, because they took the position at that time, we don't have the money, so we're not going to do anything about it. And under the taking statute, any resolution, decision, or policy, And that is the resolution that the board undertook at that time. And that is why the lawsuit was filed and why the temporary injunction was entered, to stop that resolution from going forward. Because today, under that resolution, the lakes would be dry and the dams would be sitting there de facto decommissioned without a formal decommissioning.
Okay, so what is the relief at the end of the day?
Well, the relief at the end of the day is that, one, just as the Supreme Court has said, they're either going to have to take the alternative to pay the money for the takings, for the valuation of the taking, or they have to rescind formally that provision that they have, and they would have to go back and repair and maintain the dams as all the other river authorities have done. But the Supreme Court has just come out and said that the fact finder, we can award money. Money can be awarded to us, but it's their choice at that time. They're either going to rescind that resolution and do what they have to do, or pay the takings damages. They have the choice. And that's the ultimate remedy that we have in the lawsuit, just based upon the San Jacinto River Authority case that just came out in April of this year.
Okay, so then would that be a remand back to the trial court for the takings issue and the valuation, the alleged valuation of, I guess, de-evaluation?
Correct. You would have to go back then, because as the Supreme Court has said, the Texas as well as the United States Supreme Court, all of these facts of a taking, the value of the taking, are all fact issues. That's why a takings issue is intertwined with fact issues. The trier of fact, which is the jury in this case, will have to make that determination.
Okay, thank you for those responses.
And so the fact of the matter is that we do have a right to declaratory judgment, and the trial court, and as well as GBRA, it really ignored 2007. And what's very important too, the Supreme Court also said that not every governmental action or taking under Chapter 2007 implicates these requirements. The subchapter title states that its requirements are for proposed government action. So we fall right under that definition. Now, I want to move on because I'm limited in time, and I do want to discuss the ultra-vires matter, because in this case, we filed a lawsuit against the directors and the officers of GBRA. And the suit was pled against them in their official capacity. We never sued GBRA for ultra-vires, obviously. We couldn't do that. And we had to plead that the actors acted without legal authority, or they failed to perform a ministerial act. And from the first day when counsel came in to the TI hearing, there was again another fundamental misunderstanding of what is a ministerial act and what is discretionary. And the position that we have taken is under the Enabling Act, as well as under Section 299 of the Administrative Code. And I might add that administrative code that we've talked about that requires the replacement and repair of these dams has the effect of a statute, because under Section 12, I think it's 005 of the Water Code, the legislature has delegated to the TCEQ to make the rules with regard to dam maintenance and repairs and replacements in this state. And the fact of the matter is that under the Enabling Act that requires, that says you are authorized and your obligation is to create recreational purposes and to impound waters. And when they bought these dams in 1963, they came under those obligations. And once they came under those obligations, they had the obligation to repair and replace and maintain under Section 299. It is our position, and I think it's very clear, that the ministerial act that is so clear, taken in conjunction the statute, the Enabling Act, and the regulations, which have the effect of statute by the delegation by the legislature, the ministerial act is you have to repair and replace. You don't have a choice. Just like all of the other water authorities, river authorities, I'm sorry, in the state of Texas have done. You don't have a choice. Now, you do have discretion in how are you going to do that? What kind of dam are you going to build? Is it going to be earthen? Is it going to be overmire? Is it going to be a bear trap? Is it going to be electronically controlled? Is it going to be manually controlled? Those are all discretion. The ministerial act is the fact that they must repair and replace the dams. And as the Court of Appeals in Houston said, in Houston Belt and Heinrich in the Supreme Court, when a director is sued for ultra-vires, government immunity does not apply from the outset. To answer the other justice's question, government immunity does not apply from the very outset. And in that, we are entitled to our ultra vires claims that were dismissed in this one. And as a matter of fact, Houston Belt and Heinrich both said that even if a director has some authority or discretion, still under ultra vires, if they're granted that discretion, there is a claim for ultra vires acts. And in this particular case, judges, there is no exception in the administrative code for the GBRA to delegate these duties to repair, replace, and maintain the dams to anybody else. And as a matter of fact, if you look at GBRA's brief, footnote 9, page 15 of the February 2021, they admit that they have those obligations, and they have cited the administrative code as to where those obligations and those non-delegable obligations are. Now, very briefly, since time is running out on the estoppel issue.
Mr. Sutter?
Yes, ma'am.
I'm sorry. Before you go to the estoppel issue, will you just take 1 minute and go back to standing? I know we jumped ahead, but would you go ahead and go back?
You mean where I was just starting to argue? Yeah.
Yes, sir. Just take a minute to go over standing with us, please.
Sure, I will.
Thank you.
The standing comes is because we have to have a property interest, clearly. Everybody agrees to that. And the position that we have taken is that the property interest that we have is in the permits. Because when a permit application is made, what you are doing under the GBRA rules is asking to modify their hydroelectric river property, which means that the homeowners then, under their permits, retaining walls, piers, boat slips, boat houses, boat launch, ramps, dredging, etc., which amount to hundreds of millions of dollars over the years of improvements, are actually built on the riverbed and connected to the real property. And that improvement, without any doubt in this case, no issue whatsoever, that improvement is owned by the property owner. Even though it is sitting on the bed of the river, it is connected to the property. That creates a property right. And even more importantly, Judge, under section, and the legislature recognizes this because under section 508 and 5019 of the property code, the property owners are required to disclose to potential buyers and lessees the condition of those improvements. And more importantly, they're required under section 5.019 to report fluctuations in water to those improvements. The legislature clearly understood that this was a property issue. They put it in the property code. That gives us the standing.
Thank you, Mr. Sutters. Your time is up.
Okay, thank you.
Thank you, sir. Thank you, sir.
Mr. Sales, we probably confused the cross actions with the with the regular appeal. So if you want to respond to the issue of standing, we can have your co-counsel respond to it, or if you want to proceed with the other claims made by the appellants, go ahead.
Thank you, Your Honor.
Mr. Sales, before you start, Mr. Sutter, can you please turn off your camera? Thank you. Thank you, Mr. Sales.
Thank you, Your Honor. I'm going to try to kind of refocus us on, I'm going to respond to you as an appellee that the trial court correctly granted our plea to the jurisdiction and dismissed the plaintiff ultra-virus declaratory judgment and the estoppel claims. And my colleague and partner, Ms. Stokes, is going to address that the trial court incorrectly denied the plea of the jurisdiction with regard to the constitutional and Chapter 2007 takings claim. And I'll start with the ultra-virus claim. And I think the court is well aware that GBRA as a government entity is subject to government immunity and its officers and directors. I will note, by the way, that the claims were both against GBRA and the officers and directors, despite the comment to the contrary. And the court is well aware, in order to state an ultra-virus exception to government immunity, the complaint or suit must contain specifically not about an officer, government official's exercise of any discretion, but it must be that he or she failed to perform a required purely ministerial act. And we've cited the Heinrich case, the Houston Municipal Employee Pension System case, the Houston Belt case for that proposition of well-established black letter law in Texas. And those cases go on, Your Honors, to make it very clear that you have to specify a statutory ordinance in which there's a duty that is so precisely written that it has no discretion left for the government official but to do exactly what they are asking to be done. And the fundamental problem, and the trial court correctly understood this, and by the way, Ms. Stokes is going to address this further, but this is not a novel case. It's not a case of first impression. This is a very well-established body of law on all 5 of these causes of action. They may not be this very specific fact pattern, but that's what we deal with in common law all the time, is we apply well-established legal principles to very fact principles, or fact situation. But the fundamental problem is what they have been in search of is a statute or ordinance that would require GBRA's officers and directors to operate and maintain these old hydro dams that they bought in the 60s, not in the 30s, to maintain them such that they maintain a constant level lake adjacent to their property. And I will note that there's simply no language in any statute, ordinance, or regulation that the plaintiffs have ever cited that there's any such ministerial precise duty on behalf of GBRA. And the plaintiffs never cite any such. And it's interesting because we've kind of gone full circle in this case, because the plaintiffs originally started talking about the enabling statute. The enabling statute was a broad grant of authority to GBRA, like other river authorities, to basically, they have the powers and the authority and the discretion to do a number of things on that river, including, if they want to maintain and operate a dam. But they don't have to. And that's the whole.
Mr. Sales, what about the argument that was just made that they must, according to the administrative code, they must repair and they must replace?
Yes, Your Honor, and that's what they've turned to, because after the enabling statute, they largely abandoned that and they went to Chapter 299. And I don't know if the justices have in front of you, but we supplied a bench book. And there's 3 tabs in our bench book, and tab A is the Chapter 299 of the Texas Administrative Code. And it shows the court the comprehensive regulatory scheme in the state of Texas, which grants the authority to enact rules and to enforce rules by the TCEQ for dam operation and dam safety in the state of Texas. Of note, the TCEQ has inspected the dams. They regularly are in interaction with GBRA as well as other dam owners, and they have never found that GBRA has not properly maintained or operated these dams. And there's not a citation anywhere in the record to that. And indeed, they cite no instance whatsoever of the GBRA failing to comply with a TCEQ notification under the rules that they need to do something different with regard to maintenance or operation. I'm going to touch briefly on the standing here, but I really want to defer to my colleague, Ms. Stokes, because I think it's going to address more in the takings context, but it applies equally to these 3 claims. Plaintiffs simply have no standing as basically a citizen of the state of Texas, even though they're adjacent to the water. The law is very clear. They have no greater standing than the people across the street, or you and I, if we drive up to Lake McQueen tomorrow to get on that lake. They have no standing or authority under Texas law to assert claims for alleged failure to comply with the TCEQ regulations, which is what they are doing. They're claiming that the TCEQ has a regulation that they're not enforcing us to do something to their preferred reading of those regulations. But there's no provision in the TCEQ regulations for a citizen suit. And there are, as the court is well aware, for example, in some environmental statutes and laws, there are provisions for a private citizen to bring a private citizen suit. There is no such in the 299 administrative code, nor in the enabling statute. And they concede that they're not taxpayers to GBRA. GBRA has no taxing authority. And they concede that they have no ownership interest in the dams, the water, the land under the water. And so they have no particularized injury. But I don't want to get sidetracked because I don't think there's any basis for them to actually sue GBRA. We have pointed out to the court under the water code that if they have an issue with what the TCEQ is doing, there's a specific provision in the water code. They can go complain to, first administratively, to the TCEQ. If they're not satisfied, there's a provision that they can sue in Travis County, petition the court that the TCEQ is not doing something that they think they should be doing. But they haven't done that. And it's interesting, when we point this out at their brief, I thought this was a very interesting admission in their brief, Your Honors. At page 36 and 37 of appellant's response brief, they say, plaintiffs are not moving to enforce TCEQ dam safety regulations per se, but rather have the court interpret the duties and obligations on the part of GVRA. Well, that is, by definition, this is where it morphs into a declaratory judgment action, not about the Chapter 2007. They brought a declaratory judgment action to have the court interpret to their liking the TCEQ regulations. And the trial court correctly dismissed that claim, as he did the ultimate virus and the estoppel claim, because under the Texas Supreme Court recent case of town of Shady Shores, it is clear that a plaintiff has no standing and has government immunity if the claim is not to invalidate a statute or ordinance, not to challenge the validity of it, but strictly to ask the court to enforce it to their liking. And I'll briefly touch upon the deck action claim in a moment more. But let me turn a little bit to 299.41.
Mr. Sales, before you do that, sir, Mr. Sutter, if I understood his argument correctly, he was more so asking us to focus on the permit and the structures that were built according to that permit, and how those structures were affixed to the property owner as well as to the lake or the underlying surface. How do you respond to that argument when he's suggesting that those structures in place have added value to the property owner and that potentially could be a particularized injury?
Justice Chapa, I will address it quickly, and then also again defer a little bit to Ms. Stokes on the takings part of it, because it really morphs into that. But it's interesting that at tab, I believe it's tab C of our bench book is the permit that's in the record. And
I have the permit before me.
Yeah, yes, Your Honor.
Okay.
It says the quality and strength of any construction, this is in the permit, of the above improvements must be such that they will withstand the lowering of the lake by as much as 12 feet. That's when the gates are lowered and it returns to basically its riverbed. So even in the permit, everybody understood that this is the state's property, this is GVRA's property. You're giving a permit, you're not extending any property right. And Ms. Stokes has a case right on point that a boat dock is not a property right, even if it extends on. That is just, under the Texas law, that is clear, not a property right. But they also acknowledge the very evidence they're trying to cite to this court for claiming some basis for standing. In it has an express acknowledgement that they don't have the ability or the right to have a constant level lake. And Justice Chapa, that's exactly what they're really trying to do here. They're trying to basically force GVRA to rebuild. And by the way, the word rebuild only—
Mr. Sales, I'd kindly ask your co-counsel not to shuffle papers right by the microphone, because it's very distracting and it's hard to hear you.
I'm sorry, we'll do that.
Thank you.
So the actual permit acknowledges that there is no property right and that the water can go down to 12 feet. If GVRA in its operation and maintenance decides to lower the gates, it has the absolute authority to do that. There's nothing—
Okay, but here we're not, here the issue isn't lowering the water level, it's draining the dams and the lakes altogether. So— No, respectfully, okay, well,
Your Honor,
correct me then.
There's the Guadalupe and Blanco rivers. They're just dammed up to puddle water to make a lake. Without the dams or without the gates up, they just go back to the river. So instead of the river, for example, around Lake McQueen—
Yeah, here's where the visual learner suffers without pictures. Okay.
So the river, say, is 12 feet deep. When you put the dam up and the gates up and pull the water up, it can go up to about 24 feet. And so that's why the permit says, hey, you have to be prepared to understand that this could go back to the river. It could go 12 feet. Okay. And so So it's not about draining the river. The river is going to be the river. The natural river is going to flow. We have no natural lakes in Texas. These are all dammed up man-made lakes. And these are old, small hydroelectric lakes.
Okay,
so
thank you for that clarification.
Sure. I do want to point out that I think that the 299.41, which is actually in the briefs as opposed to the argument today, was really the focus of the ultra-virus claim, says the owner shall operate and maintain in a safe manner. And as I think the court can see in the comprehensive 299 regulations that we put before the court, this is part of a broad regulatory scheme. The TCEQ inspects dams, works with dam owners, and there's broad discretion on how a dam owner, here GVRA, can operate and maintain these gates. In fact, if you've heard this, the argument, plaintiffs a bit created a straw man argument. What they say is you either have to rebuild these dams, these old dams that we, in our discretion, don't either have the funds for or don't want to rebuild but we want to work with the landowners and we'll adjacent. And we have 3 lakes that are being rebuilt, the dams being rebuilt because they formed WCIDs and taxing districts, and we helped them float a zero interest public bond to do that. But we don't have the requirement to operate these and maintain at a constant level lake. We can operate, they say you either replace it, which there's no mandatory ministerial language at all to do that, or you have to what they call decommission, which is under 299.51 of those regulations. There's no such thing as decommission. It's called removal or breach of a dam. And we haven't done that. We have the option if we want to do that at some point, but we're trying to work with people so they can put together in their local WCIDs and homeowners associations mechanisms to rebuild these, which 3 of the dams are being rebuilt through that mechanism so far. But there's a large spectrum in between. There's not a binary choice here that they're creating. In fact, we are currently operating and maintaining the dams under section 299.41, consistent with the agreed temporary injunction order, which had basically what Your Honors, what the court did in working with the parties to keep the status quo, to allow some breathing space, to allow these other solutions to be worked out, is basically saying put some no-go zones. So and signage to now, don't have boaters, don't have swimmers, don't have fisher people underneath the dams or near the dams, and you can operate them and maintain them safely that way. And we have the right to lower the gates in case of an emergency, a flood situation, or whatever. So there's this broad spectrum of operation and maintenance that we do all the time. And the idea that under the Texas law, there is no way that fits the definition of a ministerial, purely precise, mandatory duty. If they had such thing, they would cite it. They don't. It would have to be, for example, that we must maintain a constant level lake of 24 feet. Or you must maintain and operate this type of dam to this specification. That would be perhaps arguably a mandatory duty for an ultra-virus claim, ministerial duty. That's not what they're doing here. I do want to point out, Your Honors, when I was preparing for this argument, I saw a misstatement in our appellee's brief at page 20. We stated that there was no definition of safe manner. There actually is in this comprehensive set of regulations a definition of safe manner at 29.2.57. It actually reinforces our position and the court's correct ruling here that there's no ministerial duty. There's no ultra-virus claim. It basically says that the owner, again, shall operate and maintain conjunctively, so he can operate and maintain with these gates down safely, consistent with the design of the dams, essentially. So I just wanted to correct that misstatement. I want to move on in my limited time left, because I think that the ultra-virus claim was clearly dismissed correctly because it was barred by government immunity. And with all due respect to my opposing counsel, I don't think Judge Abels found that, at least with regard to my 3 causes of action that I'm dealing with today, that these were novel or unique. These are claims that are brought all the time against government officials in the state of Texas. I think a case that's very close on point is the Downing versus Brown 1996 Texas Supreme Court case, where there was a state statute that required public teachers to maintain a discipline plan in their classroom. There was a disgruntled parent who sued the teacher and the school, claiming that they didn't like the discipline that was being enforced in that classroom. The Supreme Court matter-of-factly said, no, that claim is barred by immunity. Yes, there is a mandatory that you need to have a disciplinary plan, like there is mandatory that you need to operate and maintain these dams. But there's a wide spectrum of discretion there that is left for the teacher, as it is the dam owner, to working with the TCEQ. With respect to the Uniform Declaratory Judgment Action claim, I think that there was a conflation in my opposing counsel's argument about the claim that was dismissed and the claim that on the 2007 that Ms. Stokes will address. They sought a declaratory judgment action to have this court or the trial court interpret the TCEQ regulations. We believe the town of Shady Shores case wholly defeats that case. There, the Texas Supreme Court made it very unequivocally clear that the UDJA does not waive immunity only for suits to invalidate a statute, not to bring a declaratory judgment action to say we agree with the regulation or statute, but we want you to enforce it. And that case is right on point. Plaintiffs never even mentioned or addressed Shady Shores in any of their briefs. I want to also correct a couple of statements in the opening presentation. There was no board resolution, to be absolutely clear about this, and the record is very clear that there was no board resolution by GVRA with respect to lowering these gates, not repairing these gates, or dams. It was an operational decision made by the executive director based upon his authority to want to lower the gates for safety reasons, which is in the broad discretion that he has. I also want to point out that I'm not sure I agree with our opposing counsel that a rule by the TCEQ has the effect of a state statute. So I think that there are several points in there.
Mr. Sales, why don't you agree with that last statement?
Well, I think that because of the reasons that we set forth, number one, on their standing issues with regard to the TCEQ regulations, because that you might be a taxpayer for the state legislature, but you're not for the GVRA, which is a regulatory agency created underneath and then regulated by the TCEQ. But beyond that, the TCEQ actually has the authority to make and enforce its rules for the reasons we talked about before, Justice Alvarez. And in fact, if they disagree with that, there's an actual mechanism in the law for them to go complain about the TCEQ. They're bypassing all of that steps and trying to step into the shoes of the TCEQ. In effect here, that's clearly what they're doing, and asking this court to interpret the TCEQ regulations to their liking and then try to enforce them, even though they're these vague, basic concepts without any precise ministerial duty. So I think I mentioned this before, but I just want to be clear. There is no such thing as decommissioning or de facto decommissioning or de facto abandonment. These are all, frankly, just made up terms by the plaintiffs in this case. The regulations, you can see them. We thought about like just putting a few together, but I think you need to understand the regulatory scheme. This is a comprehensive regulatory scheme that's set forth by the state of Texas through the TCEQ. And so there's no standing, and there's government immunity both for the ultra-virus and the DEC action claim. Let me really briefly address the estoppel because I'm about out of time. But the general rule, this court's well aware, the general rule in Texas is there's no estoppel against the government. It's a rare exception. It takes two elements. One is manifest injustice, and two, no impairment of government function. They fail on both elements. And the second one, they don't even try, because it's clear to try to ask an order from this court that for millions and millions of dollars to be spent by GVRA to replace these dams to their liking would obviously interfere with its function to supply water to its customers, wastewater to its customers, provide for safety in its opinion on what to do with the river and the water, and so therefore it's not satisfied. So with that, Your Honors, I would just summarize that the trial court correctly and for multiple reasons granted the plea of jurisdiction correctly and dismissed the ultra-virus declaratory judgment and estoppel claims.
Thank you, Mr.
Thank you.
Sales.
Thank you.
Mr. Sutter,
Yes, ma'am.
you have an extra 1 minute that Mr. Sales took, okay?
Thank you. I'll try to respond in somewhat reverse order. The board of GBRA clearly did approve of the resolution and what occurred. There were hearings before the board prior to the lawsuit where hundreds of property owners were present, asking the board to reverse the decisions of its officers wherein it refused to do so. So it clearly was a resolution. I want to clear up very quickly the immunity. Yes.
Mr. Sutton, is the resolution within our record?
Yes.
Okay,
Yes.
do you have a citation to that?
I would have to get it because it would be from the testimony that we had in the TI hearing that's part of the record.
Okay,
Okay.
understood.
I would have to give you that. I just don't have it on top of my head.
You can find, I just want, my main question was whether we had it within our record, the resolution itself.
In the yeah, we put it all with the transcript when I examined the directors that I called. The immunity, I want to just touch on that, is once it is determined that the property owners have standing and a property right, there is in fact, waiver of immunity under 2007. Because once a taking has been determined and that you have the basis for it, Chapter 2007, as the Supreme Court says, authorizes that taking suit and waives thereby immunity. Or if the taking has been 25% of the property, which it has been in this particular case. That's how the immunity is there. The standing issue, the property right is an easier issue to determine. The immunity comes in though in 2007 because it is automatically waived at that time. Now, with regard to the TCEQ, Mr. Sales was talking about section 5.352 of the Water Code on statutory penalties. That applies to if the TCEQ misappropriates its water. If it misappropriates its water, then we can sue. We are not claiming that any water was misappropriated with regard to this lawsuit. And what's important in the record is that every time that the TCEQ does its perfunctory investigation on a 5-year period of these dams, takes a few pictures, looks at the cracks, looked at the balding, they put at the very bottom, GBRA, you are reminded you are responsible for the maintenance of these dams. You must make all the repairs. TCEQ has delegated those requirements to GBRA. And when you look at it, some of the evidence that we did, just as an aside, that we did submit was when the TCEQ did tell GBRA that they needed to inspect all of the hinges that were corroded that caused the failure of Dunlap and issued the letter, they then had a communication with GBRA, and then GBRA got TCEQ to change the letter to basically say, what do you think you should be doing down there? So the TCEQ has delegated all of this authority for the maintenance and the repair of the dams under section 299.41 Administrative Code, where it says you shall maintain, you shall repair, you shall alter, and you shall modify these dams. So they have the obligation to do it. And it isn't, it's not an excuse to say that we should go and sue TCEQ. Under the San Antonio conservation case of 1951 that they use, that's a nuisance case, it's very interesting because it says in there that you can't bring these actions against the state or an arm of the state unless you have a legal remedy. Unless you have a legal remedy, which is section 2007, which the Supreme Court says that we have that legal remedy. With regard to the application and the permitting, the lower to the 12 foot goes to the strength of the improvement. There is nothing in that application or the permit for the modification of the hydroelectric property that says that we can drain these things permanently and leave the dams alone and decommission. So I'll let Mr. Sales know, decommission, I didn't make it up. It comes from the TCEQ guidelines. It's not in the Texas Administrative Code, I agree that. But in the guidelines, they talk about the decommissioning of the dams. The other thing that Mr. Sales made reference to was that they didn't have funds. There is no statute, there is no regulation that says you are not obligated to follow your statutory and regulatory duties because you claim you don't have money, notwithstanding the fact that a record shows they have $50 million in unrestricted funds they can spend on anything that they want. They can't delegate those duties. If they don't have the money and they can't do it, they can go to the legislature, go to the governor and say, transfer our duties to another authority because we cannot do them. The argument on the WCIDs is wholly irrelevant. Below, you'll notice, judges, in the record, when Mr. Sales tried to argue that, I objected to it and ended that argument. That is completely irrelevant to any of the legal issues in this case, whether or not the GBRA has gotten with WCIDs or whatever they're doing. That is an argument they're making to distract the court from what the legal obligations are. And quite frankly, it's something that should not be argued in this court, and certainly was something that was shut down below because it's completely irrelevant. The other thing that is important to note is that the record shows this. Prior to the failure of Dunlap in May of 2019, GBRA recognized always through the facts that we have submitted that they had the obligation to repair, replace, and maintain the dams. It was not until Dunlap failed that all of a sudden you heard, we don't have the obligation. For 58 years, they recognized the obligation. That goes to our estoppel claim. But what's more important is that in the TI order, which they wrote this provision, it states, they wrote it again, this is how important it is, nothing in this order precludes or affects in any way GBRA's obligations to repair, maintain, and replace the dams. Their language. That is what they believed for 58 years. Importantly, the Sunset Advisory Committee, after 2 years of investigation of the GBRA in 2017, 2018, came in and found that they have the obligation under Texas law to repair, replace, and maintain the dams. And that what they are doing by not doing that affects the stakeholders and the property owners who have an interest or a stake in the lakes. And in the record, you can see the response that was filed by GBRA. They did not object to that. They did not say, Sunset Advisory Committee, you're incorrect on that. They knew at that time they did it. It wasn't until the lawyers get involved with regard to the lawsuit that all of a sudden they do not have the obligation. Now, with regard to the estoppel issue, there is an exception to the anti-estoppel rule in the state of Texas. And that is outlined in the City of White, Texas Supreme Court case, Trudy, Texas Star, Austin Court of Appeals, and the Texas Department of Transportation, Texas Supreme Court case. It says where justice requires its application. We meet that because the stakeholders have spent in reliance on the permits hundreds of millions of dollars of improvements to their properties, which have helped society as a whole and the community as well as GBRA, and relied upon the representations by GBRA, not only in the application, but in the 1992 letter that's in the bench book that we submitted, saying the same thing. We are here to create recreation. We are here to impound the water. We will permit you to build if you do these things and if you follow our guidelines, and we've relied on it. So justice requires it. The second exception is no interference with the exercise of government function. And again, I think it is real clear, this is where we fundamentally disagree, but the fact is that if you look at section 299.41 that says they shall do these things that they agreed to before, the Sunset Advisory Commission agreed to before, and the Enabling Act that says you have an obligation to maintain, repair, and replace your facilities. Facilities includes dams, that they have those obligations at that time. That makes that the ministerial act. Your act is you must do it. How you do it, that's your business. We can't sue on that. But that is the ministerial act that I think that they have really never appreciated, because there is no issue on it. And again, if you look historically, judges, everybody has agreed from the Sunset Advisory Commission to the court below and the GBRA in the writing in the TI order that they have those obligations. And so having said that, I think that the court below missed the declaration that we're entitled to under Section 2007, because that is the same language as the Texas Uniform Declaratory Judgment Act. It provides us with a right to a declaration, and as the Supreme Court said, a right to attorney's fees, which is the same remedy you get when you have a cause of action under the Declaratory Judgment Act. It's the same thing. It's almost like a mini act that has been put into 2007 of the Texas Government Code permitting that. And as the Supreme Court said, that we not only have the right to move to void that decision by the board because they didn't follow Section 2007 with the takings impact study, even though they had 14 months to do it. We are also entitled to damages, the Supreme Court said. And as the Supreme Court has ruled in other cases, we'll get in the other part of the argument, is you don't have to have a taking of the entire property. Texas is coming along and is agreed with the Supreme Court of the United States that a partial taking is sufficient to waive immunity with regard to these actions.
Mr. Sutter, I
Yes,
gave
ma'am.
you 1 more minute and you took it very.
Did I do it?
graciously.
Okay.
Yes, you did. Thank
I
you
was
very
trying hard.
Thank you very much.
Sure.
Let me get the Valerie. Mr. Sales, can you come up on the video, please, and also Mr. Sutter? There's some noise in your video, Mr. Sales. Mr. Sutter, can you come up, please?
Sorry.
Yeah. Both of you, Mr. Sales, you were very candid with the corrections in your brief, and Mr. Sutter, you were very candid also. I will be very candid to you. I should have reversed the order of the oral argument, so I apologize for that. And we really appreciate you having so much patience with the three of us, and going back and forth, from the cross actions to this. So I really appreciate it. We're going to take a 5-minute break, and we will be back for the other argument. Thank you.
Thank you, Honor.
Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now back in session.
Ms. Stokes,
Yes, Your Honor.
it's your turn. Are you ready?
Yes, I am, Your Honor. Thank you.
Please proceed.
May it please the court.
It does.
At their court, plaintiffs' constitutional and statutory takings claims complain of actions that GBRA took on government property, its dams and lakes, not any actions that GBRA took on plaintiffs' property. That single fact is dispositive of this court's jurisdiction to hear both of their takings claims. Because of that fact, plaintiffs have neither alleged nor proven the requisite ownership interest in the property taken, and they have neither alleged nor proven the necessary physical invasion of their property or a current direct restriction on the use of their property. And as a result, they cannot establish either standing or a waiver of GBRA's governmental immunity. And if I may, I'll address standing first, since the court had some questions about that. I believe this case is controlled by this court's decision in San Antonio Conservation Society versus City of San Antonio that's cited in our briefs. That's a writ refused opinion of this court that has the presidential authority of the Texas Supreme Court. And the facts were very similar there. That was riverfront property owners alleging, just like the plaintiffs here, that building a commercial bridge over the river would both diminish the market value of their property and interfere with their use and enjoyment of the river as a recreational and visual site. And the court said there is no standing to bring such a claim, that the diminution in value does not create standing, whereas here the plaintiffs claim no property interest in the river, just as Mr. Sutter conceded that they claim no interest in the lake beds, which are owned by GBRA, or the water, which is owned by the state and exclusively controlled by GBRA. And the court also held in that case that there's no standing when the right to use and enjoy bodies of water is shared in common with other residents of the city and the public at large. So I believe that's dispositive of the standing issue. If the court doesn't have a question, I'll move on to waiver of immunity. I think these concepts overlap. They overlap in general, but particularly in this case, because it's fundamental that to recover under the takings clause of the Constitution, one must first demonstrate an ownership interest in the property taken. And the Supreme Court has stated this another way, but saying the same thing, that there can be no taking or damaging under Article 1, Section 17, where the government has not directly restricted the use of the landowner's property. That's in the Westgate case cited in our brief, but this court also said it in City of Laredo versus Arbela Exxon, cited in our brief. And for that reason, the courts have repeatedly held that a plaintiff has no viable takings claim when it is complaining about actions that the government took in the use or restriction of its own property, even when that property abuts the plaintiff's private property, and even when those actions have an incidental impact on the plaintiff's property, such as a diminution in market value. And those are I think the most analogous cases are the highway cases cited in the briefs, TxDOT versus City of Sunset Valley, State versus Schmidt, State Highway Commission versus Humphreys, and again, the Westgate case versus State. And like the plaintiffs here, the plaintiffs in those cases complained that the highway operations reduced the market value of their property and impacted their use and enjoyment of the property. In those cases, some of it was as commercial property and some of it was as residential property. And I think the Supreme Court statement in State versus Schmidt applies directly here, where it said there's no compensable injury because the damages they claim did not result from the taking of their property, but from the state's use of its own property, as well as the property of third parties that were not plaintiffs in the case. Same is true here. All the damage that the plaintiffs complain of stem from GBRA's use of the lakes and the dams. They complain that we haven't kept the lake levels constant, we haven't maintained, repaired, or replaced the dams. That is all to do with government property. Now, Mr. Sutter said, well, we had these permitted docks, and he conceded that those docks are built on GBRA property, which is exactly right. The permit in the record at tab C says that this is a permit for works of improvement on GBRA property adjacent to the homeowner's property. And that is also confirmed by the letter that Mr. Sutter put in his bench book at tab B, where twice it says, this is stating, trying to give you an understanding of modifications to our property, to the authority's waterfront property. So none of this is talking about their property. Now, Mr. Sutter says, well, the docks are a fixture, you know, because they touch our property or go on our property, somehow that creates a taking, and that is not correct. You know, the permits are to build the dock on our property. The fact that they may unilaterally extend the dock onto their property has nothing to do with GBRA and is not the source of any GBRA restriction or regulation. And in fact, I think there's a very on-point case called Cummins versus Travis County Water Control and Improvement District. That was the Austin Court of Appeals 175 Southwest 3rd 34, where the court in 2005 said the denial of a license to build a dock on Lake Travis does not constitute a takings of the Cummins property because the activity prohibited would have occurred on property that is held by the state in trust for the public, in which the Cummins have no rights. So there it was, they couldn't build a dock, but here they're claiming, well, maybe in the future someday, lower lake levels will damage our docks. But in neither case do you have a compensable injury that creates an actionable takings claim.
Ms. Stokes, if I might ask a question.
Sure.
So are you saying that the property owners would either have to have a property right, either say water rights in the water itself or in ownership rights in the dams themselves? Would that establish their standing and then potential takings claim?
I think that's right, Your Honor. If you're complaining about, if the property you're complaining that's been taken, the water or the lakes, you have to have a property interest in that water or lake bed. It can't just be that you're adjacent to that. And I think that's the clear import of all of the highway cases. And so, but they've admitted they have no rights in that. And there's been no allegation that they have riparian or littoral rights in the lakes, nor could they, because as this court knows, you only have riparian rights when you're in natural bodies of water, which all the 6 lakes are artificial bodies of water created by damming the river.
Okay, so what you're saying,
okay. Yes, Your Honor.
So what you're saying, even though or let's say it this way, in the event the dams are completely drained and let's say shut down and filled with, I don't know, soil, even in that case, they still would not have standing or a takings claim.
I think that's correct, Your Honor. I mean, there's no evidence of that happening in this case. That's not our facts, but I agree that they would still, under takings jurisprudence and standing jurisprudence, would not be able to pierce GBRA's governmental immunity or establish standing.
Okay. I'm just, so I'm just trying to think of, well, let me ask you this. Could they establish standing? Is their claim potentially not ripe?
Well, that's a good question, Your Honor. I mean, I think it's right to the extent that they have alleged a current reduction in the property values. They cited an appraisal district appraisal that said that property has already been reduced 28 to 35% in value. So I think that at a minimum, those claims are right. I think, if there's some aspects of their claims, such as possible future damage to trees or bulkheads that they allege might happen in the future based on their internet research, I think to the extent those aren't right, I don't think the court needs to decide that on rightness. I think the court can decide that either on standing or waiver of immunity, just as the courts did in the Andrade versus NAACP case cited in our briefs, where the court said hypothetical or speculative harms deprived the court of standing. They didn't decide on rightness. And similarly, in the Harts Bluff Ranch case of the Supreme Court cited in the briefs, they said the threat of possible future harm to property does not waive governmental governmental immunity. It doesn't state a takings claim sufficient to waive governmental immunity. So I think the court could decide it on those grounds and avoid the need to come back up several years later after many expenses and relitigate these issues. Those are all alternative jurisdictional grounds.
Okay, well, because if I'm following your argument, it seems as though you're arguing that they would never have standing, even if the water were to be fully drained, the dams were to close. You seem to argue that even in that case, they would not be able to establish standing.
I think that's right, Your Honor, because their lack of a property interest doesn't change with those facts. And it's a fundamental requirement of subject matter jurisdiction that the plaintiff have an ownership interest in the property that's being taken, that it's complaining about. Again, those are facts that are not present. These, as Mr. Sales said, 3 of these dams are being rebuilt, and then 2 of them, the parties are trying to work together to rebuild. So, did that answer your question, Your Honor?
It does. Thank you.
Thank you. I also wanted to, when we talk about no property interest in the property taken, the law also says to have and it's really the other side of the coin, but to have a taking, you have to have either a physical invasion of the property or a current direct restriction on the use of the property. And the Supreme Court has said that over and over again. This court has said it. They have never been able to articulate any they expressly disclaimed any physical invasion or occupation of the property. They said that in their briefs. And that's at 23 of their brief. And they said that below. Now, as to the restriction, I think they really never articulated any ordinance or regulation or any act that is directed at their property. And I think, this idea that there's a resolution, I think Mr. Sales pointed out that's really an operational decision. But regardless, that resolution, assuming it exists, was about GBRA and state property. I mean, by its terms, it was about what do we do with these dams? How do we operate these dams? And it wasn't about the plaintiff's property. And I think the same result obtains under Chapter 2007. And I know the plaintiffs have spent a lot of time talking about that. Now, indeed, as the Supreme Court said in the San Jacinto River Authority versus Medina case, the statute does create a statutory takings claim when governmental action reduces the market value by 25% or more of the plaintiff's property. But, and this is very important, it is conjunctive with a requirement that the governmental action have restricted or limited the owner's right to the property. And that's in 2007.002.5BI. That's cited in there's a copy in the bench book at tab B at 78 to 79. And in fact, the statute repeats the need for a restriction a couple of times in 2007.021B, which is also in tab B of our book at page 80. It even makes the deadline for filing a statutory takings claim run from when the property owner knew or should have known that governmental action restricted or limited the owner's right to the property. And then it defines private real property in 2007.024 to specifically exclude any property owned by the government, the state government, or its political subdivisions. And I think to the extent that I talked about Cummins being directly on point about docks and government property not stating a constitutional takings claims, there is also a case that found no standing to sue under section 2007.004 of the Act, where the plaintiff's property, their billboard was their property, but the property was not, it was on city land that they did not own. And the court said that as a matter of law, you can't proceed under 2007. And that's the Lamar Advantage Outdoor Company, versus TxDOT case. It's 2020 Westlaw 5666554. And it's a Fort Worth opinion, pet denied opinion. Excuse me. See, and I would just also add that the Attorney General has has promulgated guidelines under this act as it was required to do by 2007.041 of the act. And they have confirmed that the key question under Chapter 2007 is whether the affected private property is the subject of the governmental action. And so that just confirms that it has to be a direct restriction on the plaintiff's property. And I would also add on the dock issue that, I think Mr. Sutter's referring to cases that do say you can have an improvement on your property that can be compensated in a taking, but you can't have an improvement when it's not your property that's being taken on real property. And again, Chapter 2007 only applies to real property. Now let's see, the plaintiffs have claimed, well, we've established a taking because we pleaded that, as I discussed in the first argument, that you haven't done what you needed to do under your Enabling Act and under the dam regulations, maintain, repair, and replace the dam so that the lake levels will remain constant. I think Mr. Sales talked about why neither of those laws require us to replace the dams or to maintain them in the exact way that the plaintiffs wish. I would also add that there's nothing in the temporary injunction that says anything about repairing or replacing dams. And in fact, the temporary injunction expressly says that it is not, this is an agreed injunction that is not binding on future proceedings between the party. And to the extent it refers to any obligations, it just maintains the status quo and says to the extent there are any obligations, nothing in this order changes that. And that's consistent with temporary injunctions generally. But I think, independently, even if the plaintiffs were right about what these laws require, it still wouldn't say their takings claim because there's been no case, they've cited none and we found none, that says you can avoid the need to show an interest in the property taken or a physical invasion or direct restriction of the plaintiff's property in order to state a takings claims, that you can avoid these fundamental requirements of takings merely by showing that the government did not comply with some law. That would totally and fundamentally change takings jurisprudence and open the floodgates to all types of taking claims and make governmental immunity the exception rather than the rule. I'd be happy to reserve my time for rebuttal unless the court has other questions.
I do have a question.
Sure.
Let's go back to the standard of review. You heard the issue coming from Mr. Sutter that we should just look at the pleadings. What is your response to that?
Thank you, Your Honor. No, that is incorrect. As this court has stated in many cases, and in the seminal Texas Parks and Wildlife versus Miranda case, the standard for a plea to the jurisdiction is very well established. You do take jurisdictional facts pleaded in the petition as true, not legal allegations or merely restating the elements of a cause of action. You take jurisdictional facts as true unless the governmental defendant presents evidence rebutting those jurisdictional facts. Then the burden shifts to the plaintiff to raise a fact issue on those. And as you can see from the record in this case, GBRA attached multiple exhibits to its plea that we believe conclusively established that there's no takings claims and no standing. And I think that, this idea, they also said in their brief, they said various things about the standard of review that are incorrect, but not only do we not have to take everything they said in their petition as true, but we also don't have an obligation to show that they were fraudulently made. That's a line of authority that's completely distinct for amount and controversy allegations. As this court knows, the rule is if you plead for damages within the amount of controversy, if you later amend and seek damages that go above the amount of controversy limits, it won't deprive the court of jurisdiction as long as you assign it to the passage of time. And they said that's true unless the defendant can prove that they were fraudulently alleged. So that's a principle that has absolutely no application here in the plea to the jurisdiction and immunity and standing context.
And I have one more question. Assuming that we agree with you on both standing and immunity, how would you see our opinion? Do we go one or the other or both?
Well, that's a good question, Your Honor. I mean, I think there are cases that often discuss both. I think the court, can have alternative grounds. It's the same jurisdictional result, but I think the court could address both. But in the court's discretion, it can address one and not the other.
Okay. Thank you very much. You have 10 minutes for rebuttal. Mr. Sutter, there you go.
I may proceed. I
You
can't
may.
disagree enough with counsel with regard to the standard. If you look at the brief, it's very artful how they commented on it. They cited Shady Shores and saying once they raise a fact issue, we must then present evidence in a pleaded jurisdiction issue. No, that the court was specifically discussing a no evidence motion for summary judgment, which we all know the standard. And that is not what was appealed. And when they write that, they make that argument, but they don't say with regard to a plea to jurisdiction, and they leave out that it is the no evidence only. So they are wrong as they can be. It has to be based upon the pleadings to be liberally construed. As a matter of fact, below, if you look at the argument, they never disagreed with that when I argued that to the district judge. Now, I do have to respond because they didn't have the Cummins case, as I recall, in the Travis County. So I went and pulled it as counsel was arguing it. And just like I thought, this is a case where Travis County Water Authority or River Authority, whatever it is, up there, put in a water intake area. And the homeowner wanted to put a dock around it and said, I have riparian rights. The homeowner filed an application for a permit, which was denied. And the homeowner then argued on appeal, that was a property right I had. They had to give me the permit. Has absolutely nothing to do with the facts of the case we have here. Here, the applications were made, the permits were granted, and the authority was made to make the improvements attaching to the property. And this case says absolutely nothing about the property rights we have attached to the lakefront properties here. Cummings is not even applicable or on point. The second thing I want to mention is the San Antonio conservation case, because if you look below and basically in their pleadings, this is their case until they file their reply briefs. And this is a 1952 case in San Antonio where they were going to build a bridge downtown and the lights were going to shine in adjacent property owners. It was a nuisance case. And the court said the proximity to a river or a park is not enough to determine the character of a party's interest. Because what they were doing there, they were claiming a nuisance. And the court, and they were also claiming a diminution in value. And the court came back and said this, and I'll quote, depreciation in the value of one's property is not a wrong for which a court of equity, in absence of a legal remedy, would invent means of redress. In absence of a legal remedy. So under the San Antonio conservation case, if you have a legal remedy, section 2007, that permits us to have a remedy there, then the San Antonio conservation case does not apply. And that takes us back to the case that just came out with the Supreme Court of the San Jacinto River Authority case, which we were all watching because that was a Hurricane Harvey over here in Houston where we all got drenched there. And oh, by the way, there is one natural lake in Texas, Cotto Lake. I remember that from Texas history. All right. But anyway, we go back and we look at the San Jacinto case where they cited a regulatory taking occurs when the government restricts a property owner's rights to such an extent it's equivalent to a physical seizure. And they cite Hart's Bluff. Well, I went back and read Hart's Bluff. Doesn't say that, but the court can write what they want to write, you know how that goes. But this is what Hart's Bluff says. The economic impact of a regulation may indicate a taking even if the landowner has not been deprived of all economical beneficial use of the property. And they cite that, and they say Texas is moving that way, and they cite the Sheffield case from Texas 2004, and the Supreme Court of the United States that has over the years softened its language regarding loss of all economic viability. So you only have to have a portion. And if you go and look at 2007, as the Supreme Court says, the legislature has even adopted that by saying if you have 25% or more of a diminution in value under 2007. And what's important is what the court says in the San Jacinto, the economic impact of a regulation, which GBRA made, their resolution may indicate a taking, even if the owner has not been deprived of all economic benefit of the property. We have presented evidence and we have pled that immediately upon the announcement by GBRA in June of 2019 of the imminent failure of the remaining 4 dams and the actions that they were going to take to drain the lakes, the Guadalupe appraisal district of all appraisal districts went out and engaged an appraiser, Mr. Brown, which is in evidence, who came in and said immediately overnight, property values went 28 to 35% diminution in value, which made our claim ripe at that time. And the reason I kind of say that tongue in cheek is you don't expect the appraisal district to come out with something like that. You would expect us to have to go and get an appraisal on it. No, the appraisal district did the work for us.
Mr. Sutter, I have a question on what you just stated. Was the report or appraisal done with respect to the specific property at issue here, or was it generally speaking in terms of adjacent properties in the area?
It was the latter, with regard, not in the area, it was with regard to the lakefront properties on the rivers and the lakes. So it pertained to that. So that was the overall finding of the appraisal district, which the appraisal district followed in their valuations that first year.
Okay, so it's not with respect to the Williams home itself or property itself, real property itself.
No, it wasn't on that. We haven't gotten to that point in the lawsuit yet. And again, it's based upon the pleadings. We have alleged a diminution in value, and we have cited to that as some of the evidence of initial diminution in value. There was never any dispute by GBRA below that the values of these properties went down as a result of the lakes going down and the problems. That's just one issue. If the case goes back, there will be discovery and the expert witnesses. That's about all that hadn't been done in the case below is expert witnesses, their depositions and their reports on a piece by piece property. But we did have, to answer your question, we did have an appraiser who said the properties of the plaintiffs have experienced, in fact, a diminution in value. She reviewed a handful of them and also made an opinion that all of them have experienced a diminution in value and agreed with Brown.
Okay, is our focus, I can't seem to get over the hurdle, or maybe I'm making it a hurdle. This exchange between both sides in terms of what is real property, what is the dock itself or the pier, and whether because of the manner in which it's affixed, I mean, you seem to be saying that the pier itself via the permit and that establishes standing. Am I right on that, or am I, if I'm not, please clarify.
No, the fact that there is no issue below that the retaining walls, the piers, the boat slips, the boathouses, the boat launch ramps, the jet ski ramps, and all other appurtenances and improvements that are attached to the property are improvements and are owned by the property owners and are affixed to GBRA's property. And there is no issue below based upon our expert report, as well as the pleadings, because again, the pleadings state that the diminution in value and the value of those properties include those improvements. You don't have them, your property value is less. If you do have them, the property value is greater. That is what we pled. And I believe that the court on a plea to jurisdiction can't weigh the merits at this early stage, but based upon those pleadings and the fact that we have actually submitted evidence to show that there's a diminution in value from our experts report, that those are property rights. And the Cummings case is not a property right. The Cummings case talks about you don't have a property right to make them give you a permit. But once you get that permit, you have the right. That's all Cummings dealt with. They claim they had a property right before and you can't deny us a permit. Well, yeah, you can deny it. But once they give you that permit, we have that property right because it's affixed and is a value to those properties.
Okay, but you're not suggesting the Williams or any property lakefront owner for that matter, has rights in the water itself or the dams themselves.
No, they have the rights to have the improvements on the lake, and without the dams, the improvements are worthless. That's the value goes away. It's not going to be 25%. It's going to be 100% devaluation of those improvements, which are in the hundreds of millions of dollars along the lakes. So what you have to find for standing, Judge, is whether we have a property right that was affected by, as the Supreme Court says, a rule, a regulation, a requirement, a resolution, a policy, a guideline, or any other similar measure. And once we have that property right and it's affected by the guidelines and the requirements of GBRA, we have standing, and we can go forward with the takings claims that we have for the right to use and enjoy the property.
Thank you, Mr. Sutter.
Okay, and then federal going on to with regard to, because we the takings matter is that the Supreme Court said once we have that standing, taking the immunity is waived under 2007. Taking then is defined broadly to include any government action to satisfy the taking standard under federal or state constitution, or that reduces the property value by 25%, which is what we have pled in this case and which we are entitled to. And that brings us again to the impact taking study that was not taking. We have an absolute right now to have a declaration from the district court to declare that it doesn't have to be a resolution. They complain about the resolution. It can be, as the court says, under the statute, a policy, a guideline, a requirement, or a regulation, anything that's similar to that. We have a right to have that set aside because they didn't do a takings impact. You haven't heard a word from them on that. And it was amazing to me that they had 14 months to do that taking impact study in order to take away from us that cause of action that we have. And they didn't do it. And they can't claim they didn't believe it was a takings. We advised them in June of 2019 and in the lawsuit in the summer of 2019 that it was a takings, and they had 14 months at that time in order to do the impact study, which they didn't, which the Supreme Court says at that point, once immunity is waived, rescission is not our only remedy, that the fact finder can also award monetary damages to the plaintiffs as well as attorney's fees. And finally, what the holding was in that Supreme Court case is the fact that Chapter 7 waives government immunity for two causes of action: statutory taking and a suit to rescind proposed government action. Now, with regard to their cases that they talk about, the highway cases. The highway cases, if you look at all of them, including the ones from this court, which are really kind of interesting, all of them, the Laredo case, the Schmidt case, and the Hoff case were the first two, were all eminent domain cases. They were all cases where the homeowners were claiming there was a nuisance because of what TxDOT had done, or the TxDOT did not give them access to the highway, which is something I forgot. Under our permits, we are also provided a permit access to the water, which they're trying to deny us. But these cases, they say that from this court that are applicable or not, they're eminent domain. They are not. They're cases where the highway comes in and says, we're taking the land, which the state has an absolute right to do as long as there's just compensation. I'm sorry. Oh, okay. I'm sorry. Where there's just compensation.
I think I was trying to finish your sentence, but I shouldn't have done it.
I'll take all the help I can get. where there's just compensation, where they can do it. Those cases did not have where the TxDOT gave or granted a permit or a letter agreement, or where the improvement was attached to the plaintiff's property. They had nothing to do that. None of those cases do it. It was nuisance and eminent domain. They cannot apply here. I agree, the state can do that if they come in with regard to eminent domain, but there's nothing in Schmidt or Laredo that is on point of this case and that discusses what do you do once the governmental entity gives you the property right to enjoy what you own, which is the improvements, and not take them away from you without just compensation. So you know, if you look below, there are major cases where the San Antonio Conservation Society, which didn't apply, then the Laredo case and the Schmidt case, which don't apply. And now today they've come in with the Cummings case, which doesn't apply. Now, Cummings may be different if they granted the permit and then Lake Travis took away that floating dock that they were going to build up there. We all know how they're built. And they took it away. Then there would be an issue as to whether or not that is a taking. But you can't have a taking until you have a property interest. And up in the Cummings case, they had no property interest because one, it was a riparian right case, which had nothing to do with what we're talking about, as counsel agrees with me. And number two, they never got the right. They were claiming that they had some kind of constitutional right to get the permit. Well, they don't have the constitutional right. Neither do we, but we got the permits.
Yeah, let me ask you this, a property interest. So I guess what you're saying is by virtue of the permit, you have a property interest in the water?
No, we have a property interest in the improvements that are on the water, and without the water, those improvements are worthless. They have taken away the value. So no, I'm not saying that, but we have basically we have a license to build on their land, which is not revocable unless they determine it is a safety feature. You're out too far and some boat's going to hit somebody, or the boat's going to hit you and kill a bunch of people. They can make you take it down and rebuild it. Or if they move to decommission under the guidelines of the TCEQ and remove the dam. They have not done that. They will never do that because that requires notice to all the world, involvement of EPA, involvement of the school districts, the counties, the cities. It would go on for years and years and years, and they're never going to do that. They would prefer not to repair the dams and let them collapse. What we have alleged is what they really want to do is the last 4 dams just collapse, just like the first 2, and then they say, well, there's nothing else we can do about it. And I was saying the fact that they caused the collapse by not maintaining them for 58 years. But the cases that we have also cited that are important are the loss of the use and the enjoyment, and the investment-backed expectations and the economic impact, because those are things that the court looks at, which are fact issues. But we have alleged the investment-backed expectations are the historical uses. GBRA tries to paint recreation as if it is a dirty word. We all need recreation. Where would we be without it? I won't quote Jefferson on it. I think I put him in the brief, but where would we be without it? That's one of the responsibilities of the Enabling Act, is to create recreation for the citizens of the state of Texas. And the historical use has been that, and the permitted use has been that. And their obligation is to develop water for recreational purposes. And they encouraged the development. If you look at the letters and the applications, they encouraged it. And multiple millions of dollars were spent in reliance on that encouragement. And again, I want to go back to this because this section 5008 and 5019 of the property code is so important. The legislature would not put on the property owners the onus and the obligation to disclose to potential buyers and lessees the condition of those docks and improvements and the fluctuation of water if the legislature didn't believe that is a property right. That's why they put it in the property code. Because right now, if you go and sell a home on Dunlap, well, Dunlap's pretty obvious, but on the 4 existing where they have water, and you don't tell and disclose what the GBRA is doing and how long it could be that it's going to be a mud pit out in front of you, you're liable for the entire amount of that sales price. And if you don't tell the potential buyer or lessee the fluctuations in the water as a result of what GBRA is doing, you can be liable to them for the whole value. They can rescind the contract and sue you for it and get their money back. And the reason the Texas legislatures put it in the property code is because they recognize that it is a right. The last thing is we barely touched on is the constitutional taking, because we also have a constitutional right. And one of the things that I did want to say with regard to takings is that the Supreme Court of the United States, as well as Supreme Court of Texas, has said multiple times, due to the fact-intensive nature of takings cases, courts should be slow to dismiss them. because injury, damages, fair market value, temporary or permanent, whole or in part, and the taking itself are all fact issues. The court first has to determine, have you pled in a pleaded jurisdiction? Did you plead enough? After that, it goes back for the jury, the fact finder in this case, to determine. And one of the things that the Supreme Court said in El Dorado Land was a statutory waiver of immunity is unnecessary for taking cases since the Texas Constitution waives governmental immunity for the taking. So there is the first question, kind of caught me a little bit off guard, Judge, but that goes to the question that you asked at the very beginning of my argument. And I think there is no doubt, and there are just no cases. They to go up, and the other thing is that they have always claimed, I'll say in closing, that they say this is an absurd result. We will have to take care of these dams in perpetuity. No, they will not. They can move to decommission anytime they want, and they can follow the rules and do that. As I said, it's been 5 years since the first dam collapsed, over 2 years since the second, and that has not occurred. And the record shows it will never occur. So we believe that at this preliminary stage of this case, we've shown standing and we've shown immunity has been waived by Constitution and the statutory. Thank you.
Thank you, Mr. Sutter. Thank you very much. We got Ms. Stokes.
Yes, Your Honor. Well, first of all, talking about San Antonio Conservation Society, and Mr. Sutter said, well, it said in absence of a legal remedy, and we have Chapter 2007. That quote from that case was just referring to the fact that they were seeking an injunction, like the plaintiffs are here, which is an equitable remedy. Nothing in that case says that merely because a statute provides a private right of action that you are relieved of an obligation to prove your standing. And in fact, Andrade versus NAACP says the opposite, that statutes giving a right of action still require you to establish standing, especially when they use terms like affected, as Chapter 2007 does here. Now, second of all, our opposing counsel has said, well, this $40 permit that we got to build a boat dock creates a property right in those docks on state property. But they cite, first of all, a permit creates a contract right, and the permit itself is explicitly made subject to our right to lower the lake levels by 12 feet, which is what the plaintiffs are complaining is a taking here. So how could that possibly give them a property interest sufficient to establish either a takings claim or standing to pursue one? And I think he spent a lot of time trying to distinguish our cases, but I've never heard him cite a single case that says when you have a permit to build a dock on state property, therefore you have a property right for takings and standing merely because it's adjacent to or affixed to your property.
Stokes,
yeah.
Can I ask you for a big favor? I didn't catch the Cummings citation. If you can get it for me, please.
Sure, absolutely, Your Honor.
Thank you.
It is Cummins versus Travis County Water Control and Improvement District number 17, and the site is 175 Southwest 3rd, 34, and it's a 2005 Austin Court of Appeals case, pet denied. Thank you, Your Honor.
Ms. Stokes,
sure.
In fairness, though, I think his argument was that what he's trying to do is prevent the complete depletion of water and the collapse of the dams. Never did I hear Mr. Sutter argue that we don't want the water lowered to 12 feet. So, so where are we on that?
So, Your Honor, that is their complaint, is that because the gates have been lowered on some of these dams, the water in the lake has been lowered 12 feet. That is the complaint. There is a complaint that we also have a duty to repair, replace, and maintain these dams so that they operate indefinitely. But there's clearly a complaint throughout their pleadings below and their brief about the lowering of the lake level.
So are you saying that JBRA doesn't have a duty to repair and to replace?
Your Honor, I'm saying, as Mr. Sale said, we have a non-ministerial duty to operate the dams in a safe manner, subject to TCEQ regulation, and the TCEQ has not determined that we are. That the duty that he's claiming to maintain them in the way that the plaintiffs want, that's not specified anywhere in the law, much less in a ministerial manner. And again, that wouldn't establish standing to sue for takings or a restriction on their property or physical invasion of their property.
Okay, well, I just heard him say that he's trying to prevent the full collapse of the dams and the full drainage of the water. And so, I mean, that's something separate and apart and different from lowering the water or maintaining the water at 12 feet.
Well, Your Honor, I don't think, even if the water completely disappeared and it went back to the river, I don't think the water would never, actually, I should correct myself, it would never completely disappear because they'd still be the natural river. It just would not be dammed to create a lake. But even if it went back to the natural river, which it can do in some circumstances just by lowering of that amount, that would still not give them any standing to complain of that fact when they have no property rights in the river, the lake bed, or the lake. And it wouldn't create a taking of their own property, Your Honor. I would say that Mr. Sutter also referred to a takings impact assessment. One was not required in this case. The Attorney General's guidelines that I referred you to earlier say that when they're trying to inform governmental entities when they need to do a takings impact assessment, said, is the affected private real property the subject of the governmental action? i.e., is there a restriction on the private real property? Is there physical invasion of the real property? Neither one of those happened in this case, so no temporary injunction. No takings impact assessment was required. And the Lamar Advantage Outdoor Company case that I cited to you earlier, that court held that there was no standing to sue for the failure to conduct a takings impact assessment, when as a matter of law, the plaintiffs were not private real property owners affected by governmental action under 2007.044 because they didn't own any land that was restricted or physically invaded by the government. And the same is true of Mr. Sutter referred to access to the lake. Now, I would say that they've never pleaded that their access has been materially and substantially impaired, as this court said in City of Laredo is required to state a takings claim based on access, and nor could they have their access. They have not been prevented their access. But even in that situation, this court said in City of Laredo that you can't state a takings claim based on access where the government has not directly restricted the use of the landowner's property. And there, the city, they were complaining of traffic blocking a gas station, and the city had indeed declared that street a truck route and had diverted traffic to that street. And this court said you don't have standing to bring a takings claim in that event. What else? Mr. Sutter talked about, well, we've stated a takings claim because we've complained about interference with their use and enjoyment and our investment-backed expectations. What he's referring to is the Penn Central test, but the Penn Central test only applies when you have a regulation, as the Supreme Court has defined it, a current direct restriction on the use of the plaintiff's property in the first place. And then the Penn Central test asks, is that restriction, does that go too far such that it rises to the level of a physical taking? And so you just don't even go down that road, where here we have no restriction, we have no physical invasion, and we have no property interest in the property taken. We also talked about Hart's Bluff. I would say that Hart's Bluff is cited hundreds of times for the principle that in the absence of a properly pled takings claim, the state retains immunity. And that gets back to the standard of review, even if, and I think we've already discussed how Miranda and a long line of authority apply to evidence presented in the context of a plea to the jurisdiction. But even if you want to take the jurisdictional facts in the petition pled as true, they affirmatively negate jurisdiction because they are complaining once again about GVRA action on government property. They do not state any restriction that is directed to their property or any physical invasion of their property. We also talked about Chapter 2007, and Mr. Sutter is correct that you no longer, under the statute, you no longer have to be deprived of all economic benefit of your property in order to state a takings claim. And that's right. That's the legislative history shows that the whole purpose of that statutory takings claim was to change the law under Lucas versus South Carolina, where the U.S. Supreme Court said to state a takings claim based on economic impact, you had to prove that basically the property was worthless or had a nominal value, which was an extremely high burden for property owners to satisfy. And the legislators' comments reflect that they were trying to lower the burden on the percentage of your value that's been deprived to 25%, but nothing in there made a sea change in takings law that you don't have to show a property interest in the property taken or a restriction on your property. In fact, 2007 does the opposite. It reiterates the restriction requirement in 2007.05 BI, and it reiterates that you have to be a property owner affected by governmental action and that the property cannot belong to the government. If the court doesn't have any more questions, I would ask the court to reverse and the judgment on the takings claims, to dismiss them for lack of jurisdiction, and to remand to the Court of Appeals, to the trial court for further proceedings.
I don't think we want the case again.
Twice.
But anyway, thank you very much for your very impressive, and if all of you can be in gallery, very impressive and very interesting arguments. Your case has been submitted, and we will issue an opinion and judgment as soon as practicable. And by the way, if you wish a recording of these oral arguments, please contact our clerk of the court, Mr. Cruz. Okay, thank you very much. The court is adjourned.
Thank you, Your
Thank you.
Honor.